All right. Well, I think we can get started here just for the people who are on. We got a pretty good list here. I don't know, Blair, do you want to give it another minute?
No, let's rock and roll, Mr. Bauk.
All right. Well, welcome to our webinar. This is we call it Leaving a Legacy. And we call it Leaving a Legacy and not put your estate plan in place. Because a legacy gives you the opportunity to live for a purpose that's bigger than yourself. It allows you to change your family tree, not just for your children or your community or your society, but for generations to come. So you can decide to use everything you have, not just your money, but your wealth, your resources, your talent, and your relationships to bless everyone around you. So I'm Zachary Bauk. I'm the co-founder and chief investment officer of Denver Wealth Management. And if I had to tell you one thing about me when it comes to financial planning and investing and estate planning, is that I like to keep things simple. A lot of you guys on the call today, you came to us through the Dave Ramsey program. I was really drawn to Dave Ramsey because he keeps things simple, right? You pay off your debt, you have a cash reserve, you save aggressively for retirement. Eventually you pay off your house. And by doing that, you're pretty much guaranteed a solid financial plan. On the other hand, we have Blair Braden. So Blair is a certified financial planner, co-founder of Denver Wealth Management, managing principal. And I've never met a person in my life who gets excited when someone hands him a 40-page legal document. The level of nerdiness when he feels like he can save somebody 1 or 2% on their taxes is something to behold. When it comes to estate planning, you really need both. If you're just starting out, we have a whole bunch of different types of people on this call. We've got young families with kids, and we've got multi-millionaires. If you're a young family with kids, the simple approach is probably all you need. You probably really only need a simple will and a simple power of attorney because of the estate you have. But if you have a multi-million-dollar estate and the estate law changes, a small 1 or 2% efficiency change can be hundreds of thousands of dollars of difference when that estate finally settles. So depending on where you are in your life, you may need that simple estate plan. You also might need a very complicated estate plan. And that's what Blair provides. Blair provides the desire to dig into things at a very detailed level. So on this call today, I just want to make sure you guys know we do not give legal advice. You can think of us as your expert design consultants. Maybe think of us like the architects of a house. If you decide you want to build a house, maybe you buy your 20 acres of land, what's the first thing you do? Well, the first thing you don't do is go hire somebody to come dig a foundation and put in the driveway. No, you don't start building until you know exactly what you want to build. And if you walk into an estate planner's office, the first thing they're going to do is start building an estate plan for you. But that's not what we're doing today. We're basically designing the house. And if you look at the PDF that Austin sent you or the link that you got, there's 3 things that we want you really thinking about in today's seminar. The first is who. Who do I want to help? Is it a person? Is it a cause? Is it a charity? Is it an organization? That's that's important. And that's something most people have thought about. And that's where most estate designs stop. But that second one is really important. And that's what? What do we want to accomplish with this money? The way I see it, and you could say maybe I'm greedy or maybe I have a big head because of it. But if I worked hard, I saved all this money, I invested it wisely, and I didn't spend it, so I have extra money. If I'm giving that to someone, you can be pretty darn sure that I am going to send you some values and some things that I expect this money to accomplish. I'm not just going to give my kids $1 million and say, go have fun. No, there's going to be some stipulations around it. So thinking about what you want to accomplish with this money is a very important part of leaving a legacy. And last is how to protect yourself. There's 2 things I think about when we're designing an estate plan on how to protect yourself. The first is your longevity. You have to be really careful that, if you're 70 years old, you don't want to start giving away a bunch of money irrevocably and then end up living to 100, which is a lot more and more common these days, and finding that you don't have enough money to retire or you don't have enough money to be in the long-term care facility that you wanted. So you have to protect yourself with these estate plans. But you also have to protect the people you're giving this money to. An example of that would be like if you give money to your child, they get a divorce, and then the money gets split up between your child and their ex-spouse. That's something that can pretty easily be addressed through estate planning. But unless you make a conscious decision to design your estate plan in such a way that only your heirs can get the money, That's a pretty common problem that we see. So once you've designed those three things, who you want to help, what you want to accomplish, and how you're going to protect yourself, once we've designed that, that's where we take it to the estate planning attorney and say, all right, estate planning attorney, you understand the law. You're in the state that we are in. Help us build this. Help us make our vision come to fruition. And that's what we're talking about today. We're talking about the vision and how it can come to fruition. If you walk into a lawyer's office without an architecture plan, you're going to have your house in a trust, your car in a trust, your dog in a trust. Everything you own is going to be in a trust that you don't understand. And that was my joke. That was my plan B joke. So, so I can hear you all laughing, even though I can't. I just assume you're all laughing because that was funny. But you also are not only are you going to end up with your dog in a trust, you're going to end up paying thousands and thousands of dollars for complications that you may not need. So, what to expect today? Like I said, we do have a lot of people on this call, a lot of diverse situations. So we're going to kind of do like estate planning 101. We're going to start at the very most basic rules around estate planning, and we're going to get more and more and more complicated. If there's time, we are going to talk about things like special needs trusts, charitable trusts, and qualified trusts or qualified distributions. But what I'd encourage you to do is, one, feel free to type in any questions to Austin, which he'll pass along to us as we go. But secondarily, if you do have one of these special situations or you want to have a one-on-one session when it comes to designing your estate plan, that's a great time for us to have a phone call or a Zoom meeting after the webinar today, where we can help walk you through some more of these specific situations. So without further ado, Mr. Bookworm himself, certified financial planner, Blair Braden.
Thank you, Zach. I appreciate it. Thank you, everybody, for being on this webinar with us here today. I hope everyone had a chance to get home and maybe relax a little bit, pour themselves an adult beverage before we talk about dying for the next 30, 45 minutes here. However, as Zach said, I do get pretty passionate and excited about this kind of stuff. The reason being, I believe, is that I have seen it work very well when people have taken the time needed to design their estate plan. As a part of their legacy that they leave behind, their beneficiaries are left in a situation where they're at peace, they have direction, they're grateful, all these good emotions that we want them to have. Versus when it's not taken care of, I've seen the beneficiaries be stressed out, have a lot of anxiety, no direction, not sure what to do. In my opinion, one of the greatest final gifts that we can leave our children is a smooth transition of our assets and our life's work. And so that's why I get excited about it. But as Zach said, we can be pretty simple on a lot of this stuff or fairly complex. For a lot of people, though, the asset transfer portion of the estate plan can be taken care of very simply. It's through operational law, which all that really means is beneficiary designation. Operational law supersedes or it overtakes anything that is written inside of a will or a trust. So if you have your beneficiary as X person, yet your will says that asset should go to Y person, X person's going to get it because operational law overcomes what's inside of a will and trust. So it's very, very important to ensure that your beneficiary designations on your different investments and life insurance and all those types of assets, that those are who you want them to be. And now that could be a trust itself, that's fine, but you need to make sure the beneficiary is tied to who you want it to actually be or the trust you want it to be going to. We recommend that you review this at least once a year to make sure that it's still accurate and up to date. We've all heard those stories of somebody that got a divorce. This is usually where I see it. Somebody got a divorce and they forgot to change the beneficiary on, say, their 401k or a life insurance policy, and then they go and pass away. Well, what ends up happening, again, operational law, that money passes to the ex-spouse or the prior person that maybe they didn't actually want the money going to. So keep that up to date. As your life changes, you get married, you have children, you get a divorce. Those are very important things to check on to make sure things go as you wish at that time. And with that, I'm going to pass it back over to Zach so he can go through briefly what's the difference between a will and a trust.
All right, so it's a pretty simple explanation in the difference. And I'll give you guys some examples to help illustrate that. So a will simply passes out the money and your estate when you pass away. So I'm Zach. I have 3 kids. Let's say I have $1 million. If I pass away, my $1 million goes to my 3 different kids. Let's say I do an equal share. Each kid gets $333,000. The money lands there. The will is done. Estate plan is done. So a will just says who gets what. Very simple. A trust, on the other hand, gives control after death. And that's a good phrase to remember, control after death. So let's use that same example. I have 3 kids. My oldest daughter, she's 25. She's married. She has a steady career. She makes pottery on the weekends. If I gave her $333,000, it would be a blessing in her life. Okay, I'm just going to give her that money, and she's going to keep doing what she's always doing. On the other hand, my 21-year-old son, he dropped out of college. He's having a hard time keeping a job. He smokes pot on the weekends, and he's kind of going nowhere in life. If I gave him $333,000, that would severely destroy his life. It would be destructive money. So I want control over that. So I'm going to put some rules around it. And a will or a trust is really like a blank slate. You can put any rules you want around it. But maybe I say he can't touch the money until he's 30, and he has to be confirmed not doing any drugs, whatever your example is. And then my 3rd child, she's 15. Maybe that money, hey, she doesn't know about it. She doesn't need it. I'll use that money to pay for her college. And if she's on the right track, she can have that when she's 25. So a trust is control after death. And since it's your money, you can really control that however you would like. There's 2 types of trusts. There is revocable and irrevocable. And it's nice. It's not always the way in legal definitions. Those words tell you everything you need to know. A revocable trust is a trust that you can change. So if you open a revocable trust today, you can put some assets in, you can have a certain beneficiary. On any day, you can change that. It's revocable. On an irrevocable trust, that money, that cannot be changed. You no longer own those assets. The trust owns those assets. Now, those irrevocable trusts can be very advantageous when it comes to minimizing your estate tax, but it's you losing control of that money. So you have to be very wise and do a lot of thinking before you open an irrevocable trust. The other difference between a trust and a will is that a trust can go around probate, and a will typically go through probate. And to explain that, I'm going to hand it back to Blair.
Basically, probate, in my mind, sucks. It's no fun to go through. It's a complicated process that is drawn out and long. Basically, the courts are deciding who gets what. And if, they'll use the will as a starting point and where to direct assets through, but it still has to go through this long process that can be quite costly. It depends again on your state, but in a lot of states, it can be very costly. And so that can create an issue. It's a timing issue with probate, but really it goes back to that legacy again. What are we leaving our children with? What kind of emotions through our passing? And of course, they're grieving over our passing. Going through the probate process, though, in my mind, can increase that anxiety and that stress and just that pain in the neck that they have to live through to get it all settled. And as Zach said, again, wills have to be settled through probate. Trusts avoid all that probate mess, which, again, can bring more peace of mind to children. And again, we're not saying everybody needs a trust, but it's something to consider. With operational law, though, that asset transfer, that can make a lot of money move. Again, regardless of what the will says, that happens outside of the courts. For folks that have taken, if most of their money's all in liquid investments, so IRAs, 401ks, that kind of stuff, usually most of their estate is settled through that operational law piece, and the will only comes into play for some of the small leftover stuff, making the probate process way less stressful. Another issue with the probate process is during that time period, the courts have to notify the general public that, hey, Zachary about died. Does anybody want to come make a claim against his estate? Zach could have met some guy 20 years ago that came in and said, oh, yeah, Zach said he'd give me $30,000 when he died. Here's, whatever, some letter that I made up, so I get 30 grand of this. Will he? Maybe. He may or may not. That's up to the courts. But it's an extra risk that you run opening up your estate to have creditors and then just random people come in and try to take some of those assets. So in most situations, we really recommend, in really all situations, trying to avoid probate as much as possible. The trust really helps take care of that. So jumping down to the next slide here, here's a news flash. Everybody needs a will. Wait a minute. You just said only some people do. The will doesn't necessarily avoid probate. What are you talking about? Well, there's really three different types of wills. There's the final will. That's mainly what we've been talking about here and what Zach mentioned as far as this person gets this. But the living will is very important. That designates what you want to happen to you if you're in a vegetative state, say. How long do you want to be left on life support? My wife, Karen, and I are just doing this ourselves as far as the living will. Not a very fun process to go through, thinking about how long you want to be left on life support if you were, in a vegetative state, for example. But it's very important to make that decision while you have all your capacities available, again, relieving stress on your loved ones so they don't have to make that decision for you. The other type of will besides the final and the living is the pour-over will. Now, the pour-over will is just a will that you create saying, hey, if I forgot to mention anything in my trust documents or operational law, that it shows up into this pour-over will. A lot of times that's like cars or a piece of art or something. And that pour-over will then also has a beneficiary that tells where all those assets go. So those, I think pretty much everyone needs the living will and the pour-over will. Some people need the final will, depending on if they have the trust or not. The other news flash, everyone needs a power of attorney. What is a power of attorney? A power of attorney is some person that you've designated to make decisions on your behalf in the case that you're incapacitated. It is a nightmare of ours as financial planners of having a client that doesn't have a power of attorney. Maybe something happens to them where they become incapacitated. They have plenty of money to pay for the medical care that they need. However, there's no power of attorney to allow us to release funds to pay the doctor's office. With that simple form, we can say, okay, Mr. or Mrs. Power of Attorney, happy to send some money out of Mr. Joe's account over here to help pay for whatever expenses there are. Now, I've had some people mention to me, well, that's kind of scary, giving control to somebody else to make decisions on my behalf. I've seen a lot of power of attorneys that have what are called screening provisions inside of them, meaning that this power of attorney does not come into effect unless at least 2 medical professionals certify that I'm mentally incapacitated and cannot make these decisions on my own. So that can give you a little peace of mind that, yes, I can have a power of attorney there if I need them, but if I don't need them, they can't do anything. So that can be quite helpful. Again, I think everybody needs these sort of estate planning documents. Getting into a trust. Who needs a trust? Now, we're going to go through several different examples here. As Zach mentioned, there might be a trust needed for control issues as to who gets what when. You might want to do it for tax planning purposes, and we're going to, again, talk about that in a second. One reason why we see a lot of people need trust, though, is due to the real estate that they own. Again, going back to the beginning of the presentation, operational law, that's very easy to establish on our things like IRAs, 401ks, life insurance policies. It's much more difficult, though, on your home. You can't list a beneficiary on your home. I've had some clients say, well, I'll just give my house to my kids, before I die, and that way I don't have to worry about that. Well, there's a tax issue with that I'm not a fan of. But there's also a control issue that I'm not a fan of. Unfortunately, I heard a real life story here in Denver to where, long story short, the parents gave their house to their children. And I don't know what went awry. I don't know if the turkey got overcooked at Thanksgiving or what happened, but there was some strife between the children and the parents. The children actually evicted the parents from their home that, was their family house. So I don't like that either, giving the asset away before they've passed, giving all the control away. But I don't want this house tied up in probate. So the trust is a great way for a lot of people to own real estate through their trust so that it avoids probate. They maintain all control and ownership while they're still alive. This becomes especially important when they own real estate in multiple different states. Probate is a state-specific issue. So if you own houses or real estate, whatever, in 5 different states, and there's no trust involved, your beneficiaries could be left in a situation where they have to go through probate in each one of the states that you own real estate. A way to, again, leave them with more peace and gratitude versus anxiety and confusion is to wrap all that real estate owned up into a trust that you own and control. At your passing, avoids probate and goes to who you would like it to go to. So that's, in my opinion, a great reason for a lot of people to get a trust is when they own multiple pieces of real estate. If it's just your primary residence, maybe there's a simpler way to take care of it that we can talk about offline. But when you own multiples, especially, great time to think about a trust. With that, though, I got a trivia question for you, Mr. Bauk. We're jumping into taxes now and how a trust might help with taxes. What is the difference between tax avoidance and tax evasion?
All right, I'm going to go with tax evasion, you end up in jail. Tax avoidance, you also end up in jail. It's a trick question.
Kind of. It is a prison sentence. That's the difference between the two. Tax avoidance is totally legal. Tax evasion, totally illegal. So we always want to follow the letter of the law, especially when it comes to the IRS and the tax code. We can absolutely do tax avoidance per the IRS tax code. Tax evasion is nothing we want to mess with. Trust can help us with tax avoidance, estate tax avoidance. So with that, Zach, I'll hand it back over to you a little bit to talk about what is the estate tax, what does that look like?
All right, so the estate tax is something that has moved around a crazy amount. I started in this industry in 2008. When I started, the estate tax was $1 million. So any estate over $1 million, you'd pay the estate tax. You can see on the left-hand side of the screen, we have that 18% and 40%. Really, for all intents and purposes, almost everything is taxed at 40%. There's this very short, steep, graduated tax rate. But in reality, you can just say the estate tax is 40% and you'd be pretty darn close. But over the last 12 years, it's gone from 1 million to 0 to 5 million to 11.5 million. And as of today, there will be a sunset in 25 back to the $5 million number. So what does this tell us? Well, it tells us two things. The first thing is that we have no idea what estate tax is actually going to be when you pass away, because we don't know when you're going to pass away. We don't know who the president, the Congress, or the Senate will be. Second of all, it tells us that your estate plan has to be a living document. Now, you don't probably need to update your estate plan every year, but you do need to update your estate plan when there are major changes in your life or major changes in the law. So if you have, if you're leaving money to your kids and grandkids, you have another grandkid, well, that's a time to update your estate plan. A new president gets elected and the exemption goes from 11.5 to 4.5, you might need to update your estate plan. And that's really the takeaway I would give you guys from this slide, is we need to make sure that you think of this estate plan as a living, breathing document. In addition, so these 6 states, these are 6 of the states that people on this call represent. Not every state has an estate tax, but Illinois and New York do, as well as Oregon and a bunch of other states. So this is certainly not a comprehensive list. But where you live will affect your estate. So that's another thing to be cognizant of. One of the ways the slide says protecting against estate tax, like Blair said, our little slogan around here is don't mess with the IRS. Don't do anything that's going to get you in trouble with the IRS. Don't bend the rules, don't break the rules. But there are legal things you can do to protect against this estate tax. And one of those things is gifting. In 2020, you can gift $15,000 per year to an individual. So if you are in the situation, and we have people on the call in this situation, where you will have a multi-million-dollar estate, and if the estate tax sunsets to $5 million, you're probably going to be paying a good chunk of estate tax. It might not be a bad idea to start gifting money on an annual basis to the people who are going to inherit that money in the long run. So, in short, or in conclusion, you have to make sure you're paying attention to the law. That's what we do. That's what we'll help you do. That's what our estate planning lawyer is going to do. And we have to be very aware of what's happening on a government level. And then Blair's got Blair's always on a portability kick. So I'm going to have Blair explain what portability is.
Thank you very much, Zach. I'm passing it over. And yes, just to clarify, basically on this slide, if one person could die, have $11.5 million that has no worry about estate tax, anything above that starts getting hit the estate tax on it, the 40%. And again, as Zach said, that changes all the time. Well, so this next slide is going to be more relevant to our married people on the call. There is something called portability. If each person right now in today's terms gets $11.5 million. So as a couple, call it $23 million that we can pass to the next generation without having to worry about estate taxes. It is very common for a lot of our married couples to establish AB trusts. And I'll get into what some of this means and how it works. But effectively, it accomplishes several different things. But one of the main things that it accomplishes is it ensures the surviving spouse the ability to utilize their deceased spouse's estate tax exemption amount. So again, on our own, we have $11.5 million. If we have things set up correctly, when one of the spouses dies, we're able to add their $11.5 million on top of ours to get the maximum allowable amount and do some tax avoidance for our heirs through the estate finalization process. So again, when the way these things work, when one member of the spouse passes away, there's actually two trusts created. And one of these trusts, the surviving spouse is allowed to utilize that trust for anything that they would like to, and for health, education, maintenance, sustainability, all the things that they might need to take income out of it. But one thing they cannot do with that trust is change who the beneficiary is. It must stay the same as designated by the married unit, while they're both alive together. So you die, your spouse, maybe they marry the 30-year younger pool girl or pool boy, and that would be a worry of mine that, shoot, all this money my wife and I have made, it's going to end up going to the pool boy someday if we're not careful. Well, the AB trust can help with that as well. And then again, it gives you the tax benefits, but also ensures that your surviving spouse can utilize that money while they're living. But ultimately, when they pass, the residual amount left in that account has to revert back to the beneficiaries that you two established together while you were still both living. So again, the AB trust, pretty dang common with a lot of our clients, and something that a lot, all attorneys, estate planning attorneys are going to know about this. It's a good idea to know what they are before going into that office and kind of what you're signing yourself up to. With that, I think we have some time here, Zach. So maybe let's dive into what some other reasons why somebody might need a trust are.
I got it. These are all types of trusts that not only do we advise on, that we manage for different types of clients. So the three types are special needs trusts, charitable trusts, and qualified charitable distributions. For most people, these trusts are not relevant. But for people who have a situation that calls for these trusts, it's absolutely essential. So a special needs trust, there's a lot of reason for them, but the main reason is that you have someone in your life that has special needs, and they require, well, there's a lot of reasons, and that's why it's hard to get into the details. But if you have a child who has special needs and they're going to need a lot of help after you pass away, you can set aside money for them in a trust in such a way that they can still get benefits from the state, whether that's local or state, local, or federal. But if you don't have a special needs person in your life, a special needs trust is not something that you come across, but that is something that we implement and administer for people. We're not the trustees, but we manage assets for that. A charitable trust is great if you are very financially secure and you give a lot of money to charity and you are not afraid. We talked about the who, what, why, protecting yourself. If you have assets that you're not worried about giving away permanently, a charitable trust or a charitable remainder trust, there's some very beneficial tax advantages to giving a large sum of money away early in your life. That's another type of trust that we administer. And qualified charitable distributions, once again, that's for someone who gives large, it doesn't have to be large amounts, but you're giving but it generally, like everything, the more you give, the more beneficial it is from a tax perspective, that you can give money from an IRA instead of a non-retirement account. And there's a certain tax advantage to you to do these qualified charitable distributions. So that's kind of an overview of those three types. If you have any specific questions about those, feel free to ask. I don't want to spend too much time on them because I think there's a lot of people that it's not relevant to everybody on the call. But Blair, is there anything you'd add on those different types of trusts?
Yeah, I mean, not a ton. The qualified charitable distributions, that's not technically a trust, but it's a way for you to do some tax avoidance and be charitable. There's, rules around that. You have to be a certain age and all kinds of fun stuff. But, we can help out with that, certainly. The charitable trust, all kinds of different types of charitable trust. And, some you have to give up all control. Some you still maintain some control and benefit through. So it's really, again, what you're trying to accomplish with that. And those are things that we can help work you through. If that's a goal of your families, is to be philanthropic in nature, you have the assets to support it, and you'd like to save some money on taxes, then we just need to explore really what you're trying to accomplish, what are the needs are, and we can help talk to you about the different types of trusts that are there. By all means, were these trusts that we talked about today not all encompassing? There's several other types of trusts out there that we did not hit on that, again, are going to be more unique, more specific. But that's why we think it's important to sit with folks like us in the design process to be able to decide what types of trusts really make the best sense for my family and our situation. So that's really it on that one. But kind of jumping down to the next slide as to, all right, at this point in the conversation, we've talked about death for a little while. People are probably, hopefully a couple drinks in for the evening. But you might be thinking, man, this is a lot of information. What the heck do I do at this point in time? Zach started the presentation off with the first step. You have a handout that was provided to you, or a PDF, whatever you want to call it, that was provided to you. That's the very first step, figuring out the who, what, and why. Get that form filled out. Another document that you got was basically your asset inventory list. You need to start writing down everything you own, how it's titled. That's also very important for estate planning, who the beneficiaries are, and the locations of those assets. Once you have those two different pieces filled out, you are ready for the design piece to come in, sit with us, go through all that kind of stuff, talk about the different types of trusts that might be appropriate. And we're trying to get you more prepared to go sit with that attorney so that your time with them is pointed and it's hopefully shortened, and hopefully your cost with them is lower because you're prepared. You're ready to go on all of this. And so those are the steps, filling out those things, giving us a call. Let's talk about it, help talk about different situations. But yeah, with that, my call to action to everybody is definitely, think about this, take this serious. This is something to, unfortunately worry about until we get it done. And once we get it done, it's important to review it and monitor it as time goes on, make edits as needed. But there's a lot less stress at that point, knowing that we've got this done, our beneficiaries are taken care of, we're monitoring it as time goes on, making edits. And then it's up to us to live a healthy lifestyle and try to put this stuff off as long as possible as far as the actual implementation of all these things, i.e. dying. Let's put that off as long as possible. But that's basically the design process, some ways to get started with it. And with that, we would love questions, and hopefully we can answer for you. So, Mr. Austin, do we have any? It's, again, not the most fun process to go through this. Very important. Please, though, take the time for your children, for your beneficiaries, for your causes. Please take the time to go through this, get it established, and it'll be a sigh of relief knowing that, hey, you've taken care of this. Certainly, it breaks our heart when we see these things not go well. And unfortunately, that still happens several times a year. If it's one of our clients who are a beneficiary, usually that's how it works, that they're trying to figure out their parents' stuff or whatever it is. And it's just, we don't want anybody in that situation, and we can take care of it now. And this is not crazy expensive to get this stuff done. We're not going to charge you anything to chat with us about this stuff, but even the attorneys, they're to get this stuff done. It's, in my opinion, we don't want to be penny wise and pound foolish. We need to be willing to spend some money to get this stuff taken care of, making it easy on our heirs so that they have a boring story about how they inherited all this money.
And I'll add there that I love that, a boring story. That's going to be Austin. When next time we do this, it's going to be called a boring story. I love it. We are all just passengers on this earth. If we're blessed, if we're lucky, we have 100 years, and most of them we have our health. But we all know the end game here. So I just think of this legacy journey as a chance to be a hero. It's a chance to leave so much more than your money. It's a chance to leave what I started the talk with, your wealth, your resources, your talent, and your relationships, and to bless the future generations. So if you're thinking about this in the right way, this is so much more than just who gets my money. I mean, it is a chance for you to be a hero for multiple generations. And I think if you can come at it with that perspective, you're just this process will go from, Blair's right. Have a cocktail before you sit down, because it's some pretty heavy duty stuff to think about. But I think by the time you're done, you can really feel like you've done something incredibly valuable, not only with your life, but for future generations. So this can be a really important part of your life. And I encourage you to embrace it as that.
Thank you, everybody, so much. Please think of us as your designer on all this. Please let us know what questions you have. If we can help in any way, we are honored to do so. And we will see you all for our next presentation. Austin, do we have any events coming up? With COVID, it's crazy, but anything that we want to leave folks with Denver Wealth Management, anything we have on the docket, or ways folks can stay engaged with us if they like this type of material?
If you like this kind of material, make sure you're on the email list. That's the main way that we are passing this along. I wish I had something for you, but as Blair mentioned, with the virus, it's been tough. Keep an eye on the events calendar. We'll keep doing webinars. We plan to do more educational webinars next year. If there's anything specific, please let us know. Please pass that along, and we'll see if we can get something scheduled. But thank you all so much for being on the call.
How do people sign up? How do people sign up for our email list?
Good question. On the website, on almost every page, it's either on the bottom or on the side. You just put your name, put your email, and we'll take care of the rest. We'll send you some good stuff.
Thank you, everybody. Have a wonderful evening.